Dr. Kizza Besigye yavuddeyo n'ategeeza omulamuzi nti yakwatiddwa munda mu kkomera mwe yabadde n'ateekebwako empingu ku mikono ne ku magulu n'akakibwa okutwalibwa mu kkooti enkulu. Jjukira nti nno Besigye ne banne bawakanya ekya kkooti okugenda mu maaso n'omusango nga tebalina balooya baabwe. Anti looya omukulu Martha Karua gavumenti yamudipootinga bwe yali azze okuwoleeza Dr. Kizza Besigye ne bamuzzaayo Kenya, ate nga ye Ssaalongo Erias Lukwago yakwatibwa era naye naggalirwa mu kkomera. Ekitegeeza nti tebakyalina balooya. Gavumenti yagezezzaako okubafundira balooya wabula bo baagaanye ne bagamba nti baagala balooya baabwe. Biibino nga bwe byabadde mu kkooti.
We were arrested from the prison and brought here forcefully. First time I'm being arrested in prison. So we didn't come prepared. If what I heard and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly.
Special case number 335 of 2025, Uganda versus Kampala Dr. Kizza Besigye, Adebe Interim R. Stroke 12743, Captain Nicola Elishoya.
May it please this honorable court. I'm Thomas Jatiko, Assistant Director of Public Prosecution. And I'm appearing together this afternoon with Richard Gumbuka, Chief State Attorney. My lord, the three accused persons are present in court. However, my lord, the counsel representing the accused persons are all jointly and severally not present in court right now. My lord, this matter was adjourned to today, the 13th. July. For hearing of the prosecution case as per the ruling that we received, and while the prosecution is ready to proceed.
said you are ready to proceed.
Yes, the witness is in the court premises.
The
Not,
witnesses are
they are around, not inside the court here, my lord.
ready to remove.
I came here by duress.
Then first remove them. Remove the handcuffs, then they are present.
Yes.
Sign the report on the issue of legal representation while they are making
Yes.
legal representation.
Judge, when we were last here on the 3rd of July this year, we did address court on the challenges of our representation. And that we had filed an application number 248 seeking remedies relating to our representation. That was not responded to. And actually on the very following day, on Saturday, the 4th, Mr. Museveni addressed the country touching on the matters before this court. In his long address, the long and short of it that I picked related to our case, is that there is indigenous community justice.
Let me first get the reason why the lawyers are not here.
I am explaining the background to that.
No, the matter was coming for hearing today.
Yes.
So tell me why the challenge you have for legal representation, why they are not here. I want to capture that.
Yes, so I'm talking about the reason of fair hearing, which requires us to be represented by lawyers of our choice. But the reason I am referring to what? Yes.
The reason is a fair hearing
Yes.
by the lawyers of your choice.
Through a representation by lawyers of our choice. And the reason I was referring to what was said on Saturday is that belief of ours that we have a right to a fair hearing with the representation of lawyers of our choice is clearly in question. what?
Is there anybody who has refused you that right of the choice of the lawyers?
Yes, there is.
Moving now.
And that is the subject of the application we made to this court on application 248. We were surprised that indeed, in spite of what the representations we made here on the card, which included 3 main points.
This application is about what?
3 main points. The application is mainly about legal representation. But beyond that, I addressed you on the question of us receiving the evidence that was given to our lawyers. It was read, a letter was read in this court on the 3rd. Permitting access to us by our lawyers with the facilities to hear the disclosures. That letter was written on the 2nd of July. Which was read in this court on the 3rd.
I would say still there is a challenge to access the facilities.
Of course. So, up to today, we have not, because that is related to our legal representation. We want to hear the evidence together with our lawyers. We haven't had the opportunity to do so up to today. And I made this very clear on the 3rd.
So, kindly be specific, the challenge with legal representation, why they are not here.
So you want to listen to the application?
So it is in that application?
It is in the application.
248.
Absolutely. That application was even touching on the earlier application, 227, where we never served the respondents.
So you are saying
that application you gave a ruling even before we served the correspondence and the respondents in that application. Application 248 was actually also seeking for substituted service so that we could serve the respondents in 227 in the application number 227. Which now has already been ruled.
So you are saying that now there is that one pending, 248.
So there is application 248 pending. There is access to the disclosures, which we have never had. And we had also requested, the third issue we had requested for a record of proceedings.
For which one? Because the records are mainly
A record of the proceedings so far
in the main.
in the main case. In the main and in the application that we had made. And regarding that, it was even a part of what was presented by Counsel Erias Lukwago among the 7 items that needed to be dealt with in the preliminary hearing.
So let me know those challenges you have in legal representation now. What is your issue? What are you requesting?
So, our request, which I made even on the 3rd, was not responded to, is that our application 248 be had, so that we can resolve the question of representation. Once the question of representation is resolved, we shall have access to the disclosure. Hopefully then, in that period, we shall also have had the record of proceedings, and we shall be ready for trial. Nobody wants to stay in prison. And this is why, Mr. Judge, the address of Mr. Museveni on Saturday 4th is critical also in this case, because he addressed the nation, the whole country, on our trial. And on something totally unknown to me called the indigenous justice system.
We need to know, let me first conclude the challenges now for commencement of the trial today. I have seen...
So the 3 challenges...
There is a pending application.
Yes.
The record of the proceedings.
And the disclosures which follow on the representation. And these are not new demands. They have been before this court in writing and orally.
So let me get this. The disclosure which were made to your lawyers, are you saying you want also to give it to you?
They are for us. We haven't received them because we need facilities to do so. And that's what I was complaining about last time, because we made presentations to court, they are totally ignored, and matters continue as if we did not say anything. And that's why today we had said no. And we wrote a letter. Unfortunately, that letter I think also was detained by the prisons. We wrote a letter on Friday last week, expressing further our dilemma. Having received the ruling, I think that day, saying that the hearing was to begin today, we wrote a letter on Friday. I doubt that it is yet before court. The prisons have it. So we have challenges in prison, we have challenges in court. address you on the environment that has been caused now by the address of Mr. Museveni on Saturday on this case, because it is before you.
Let me first listen the challenges for hearing today and why the lawyers are not here.
And then I will come back. No
I
problem.
must resolve that.
My Lord, for record, Captain Dennis Oyamora, Adrian. I want to be very brief. Most of the things have been said by everyone. But I want to talk specifically concerning myself and possibly why the lawyers are not here. The last time we were here on third,
The reason why the lawyers are not here is
when we were here on third, you promised to give a ruling of that day by 8. As I talked of now, I've never received any.
I've never received one.
The ruling of that day. And even coming to court, I was just told today by 9.
What the ruling they are putting?
You promised to give ruling on that day.
Did
I did. Not at all. And for today's hearing, they did not tell me that I was coming for hearing. They just informed me that I'm coming to court today at 9. I had no idea that court would be there today. And therefore I have never contacted my lawyers. And I'm not sure whether they are also aware that court was supposed to be there today. So, to tell court why they are not here, I'm really not in the position. Because personally, I never knew there was court session today. It's my prayer that next time service of such should really be done to all, so that we can prepare. But in addition, there is still also need for me to have access to the facilities, and so that I can get to understand what is in the disclosure. Thereafter, I will be ready for hearing. Thank you.
Please, when I get to me,
But you are given a dozen.
you still want to say,
Yes.
I don't think I hear.
Yes. Mr. Judge, the reason again, all these touches on the fair hearing, you know,
I'm giving you another chance to address court on the legal representation, which is affecting today's hearing. So that I'm able to respond.
I have addressed court regarding the legal representation. I want to address court regarding the statement of Mr. Museveni, which touches on the fair hearing of this case.
That one, today we are not handling that. Today it is here. So let me get the challenges you have for here.
Precisely, this is a challenge for our hearing. Because statements that were made touch on this hearing.
That one I have captured that.
Yes, so let me tell you what they are.
No, you can't go to that address. I need to know the challenge you have to go to court.
That is a challenge. The address is a challenge. Because it's an address to the whole country, it affects the nature of this case, it influences the assessors, it influences everybody in this case, including yourself.
I am saying that you can address me, if you have already addressed me on the challenges of legal representation.
Yes, and this is a challenge on this fair hearing before you. So I can go ahead and address you on it.
You have addressed both of the challenges of legal representation.
Yes, I'm not addressing you further on the challenge of legal representation. I'm addressing you on what Mr. Museveni said on Saturday the 4th, which has
the problem before court to resolve is legal representation, the challenge.
So when do I raise this?
You said there is an application. You want me to listen to the application in court? You said there is a pending application.
Yes.
You want to add it to now?
The pending application is on the representation.
And that's what we are handling now. So what you are saying, we cannot go to the merit that case. What you are saying. But today let us handle why you cannot go.
I don't know whether you have received the letter we wrote on Friday to this court, because it also contained some of these matters.
You also wrote a letter?
Yes, which is with the prisons authorities. And they are here, maybe they can confirm whether they have brought you to have it.
About the same.
Yes, about these issues. I want it to be on record.
So that road, so that
So the letter has been received.
I will go with the question. I will go with it. Can I know the letter? Was it what did you defend?
Yes, my lord. My lord, I'm assistant superintendent for prisons. Superintendent of prison. For the letter in question, I'm assistant superintendent of prisons, Hero Emmanuel.
Yes, about the letter.
My lord, all articles written to go through a verification process before they are forwarded. All articles written by the accused, they undergo a verification
Is
process.
this for what they do is still undergoing? That's what it is.
I get to confirm the status of the said data.
You are not sure what's going on.
Yes, my lord.
Okay, let the state reply on those issues.
to appeal your ruling. Appeal the ruling in our application 37. And we then need the record of proceedings to proceed with that appeal.
So the notice of appeal which ruling
In the ruling of application number 227. That is the human rights enforcement application.
it's noted. So state.
For record, my lord, Richard B. Vonka, Chief Secretary. For prosecution. My lord, in response to the issue of representation, the accused persons, maybe to start with A1 and A2, maybe that's why it is more contentious. Are represented by more than 35 lawyers. A1 and A2 are represented by more than 25 advocates. And they have been on record since this matter, my lord, moved from the Chief Magistrate's Court, Nakawa, to this honorable court. My lord, would appreciate the right of the accused persons to legal representation and more so by advocates of their choice. As envisaged under Article 28 of the Constitution, and Section 56 of the Trial on Indictments Act. Because it constitutes part of the fair hearing. My lord, since the last sitting, A1 and A2 have been unrepresented.
And in this submission, that is our senior citizen and great statesman, Dr. Kizza Besigye 1, he submitted that the lawyers were not in court because Senior Counsel Martha Karua,
You mean today?
last time, even last time, yes, my lord.
But reply.
Yes, I'm bringing my thing properly, my lord.
Yes, but reply. Bring.
I'm reverting it, my lord, because without that I can't make my point. He argued that they were not in court simply because Martha Karua and
Mr. Rico.
yes, my lord.
I didn't hear you talk about Massa and others. We first help court to address the concerns, their concerns today. Why this?
My lord, it's going to help you in this matter very well.
No,
But I'm not going to do it
first
much.
vote is
Okay, my lord.
issues today.
My lord, we have never received any notice we have never received any notice of withdrawal of instructions from any of his lawyers. And actually, even the key persons, that is A1 and A2, have equally not informed this court that he withdrew instructions from all the lawyers who are representing him since this matter started. So the assumption is that the instructions are still active. So therefore, when the accused person appears in court unrepresented the way he did last time, it's becoming habitual. And my lord, it is either unexpressed or implied notice to this court that they have waived their right to legal representation of lawyers of their choice. And my lord, this act is frustrating the hearing of this matter, because the principle of fair hearing, all the issue concerning hearing is not only about the accused persons. It is about the accused persons and other parties that are involved, including the public. My Lord, ever since we did our last disclosure, which is I think a month or plus ago, prosecution has been ready to have this matter heard. But you have been arm-twisted, always. And there has been a picture that has been painted to look as if prosecution is the one frustrating the trial or the hearing of this matter. We want to make it categorically clear that we have been ready to have the accused persons tried. Today we have witnesses and we came ready to have the matter heard. My Lord, this in effect constitutes an abuse of the legal process. And my Lord, if the accused persons are abusing the process, this court, my Lord, has tools at its disposal under Section 17 of the Judicature Act to make a finding, my Lord, among others, that the accused persons have waived the right to legal representation of their choice. My Lord, Section 17. My Lord, Section 17(2). With regard to, says, with regard to its own procedures and those of the magistrates' courts, the High Court shall exercise its inherent powers. A. To prevent abuse of process of the court by curtailing delays in trials My Lord? Okay, most obliged, my Lord. So, my Lord, I will submit that this court can make a ruling, a finding, based on that provision, that the accused persons have given up. They have waived that right to legal representation of their choice. The assumption, my Lord, here is that under those circumstances, it becomes a voluntary waiver where most obliged, my Lord. And my lord, the court in doing so, it can direct the matter to proceed for hearing. And in alternative, court can appoint lawyers on state brief to represent the accused person. And my lord, it is our prayer that court makes a ruling to ensure that we have the matter tried. We are ready. Because if it doesn't, it's going to create anxiety in the mind of our witnesses. And some of them may end up not testifying. My lord, as prosecutors or DPP, we are not party to application number 248 of 2026. We are not privy to it, and we are not aware of its contents. And my lord, we are also equally not aware of the effects of the speech of the president in regard to this matter. My lord, this court is independent as per the Constitution, and this matter will be tried best
Are you responding
on
to
the
what
facts,
you just said?
evidence and the law.
He's saying
He wasn't allowed to say what
he didn't address that matter.
Most obliged, my lord. Most obliged, my lord. But he said about it, my lord.
Yeah, but I said it is not here, so it
Most
was
obliged. My lord, we so submit.
Yes,
an opportunity to respond in the remainder of what
yes, very briefly, Mr. Judge. The application to file was filed last month. It was raised to the attention of this court on the 30th of June, when we came here to this court. This is also a human rights enforcement application. That we expected would be dealt with as a priority. If it had been dealt with, we would not have been in the dilemma we were on the 3rd. We would have resolved the issue of representation. It was not attended to in the hearing of 30th. was not attended to in the hearing of the third, in spite of raising it in both appearances. The circumstances that propelled that application were not of our own making. They were the making of the state. Which kidnapped Council Erias Lukwago and tortured him. And which arrested and deported Council Martha Karua. These were the actions of the state. Illegal actions of the state. If they hadn't been there, there would be no application 248. We would have proceeded normally. The details and the evidence in that application can only be dealt with by hearing the application. And if it's baseless, dismissing it. Regarding the lawyers not notifying prosecution, regarding their lack of instructions, that would be a matter for the lawyers to deal with. It cannot be visited on us. But suffice to say that both on the 1st of July and on the 3rd of July, in this open court, we did on the 30th of June, and on the 3rd of July, in this open court, we did put on record the situation of our representation. In their presence.
This challenge, how long, according to you, how long can we wait on this legal representation?
If 248 can be had tomorrow and resolved, then the following day we would have a way forward. It hasn't been had since we filed it last month and talked about it in these subsequent appearances. Again, for emphasis, since it seems Chief State Attorney Birumomuka didn't get it, the disclosures were made to our lawyers. For us to receive them, we need the facilities through the prisons authorities for the lawyers to now make us access them. So, whereas trial, and indeed they said they had a witness here on the 11th, they had a witness in court. But on the 3rd of July, they themselves read a letter that was now, for the first time, allowing access to facilities, which was written by the prisons authorities on the 29th of June. So we were supposed to hear evidence on the 11th, long before prisons considered to allow facilities to access the disclosures. By the 2nd of July, when that letter came to our notice, and I'm sure to their notice, the crisis of the lawyers had already emerged. So we have no way of accessing them since July the 2nd, when that letter was written. And until the resolution of the legal representation which they are seeking. Regarding what he describes as abuse of process, then I think there must be completely different understanding of the judicial system, the legal and the judicial system we are following. Mr. Berivumuka must be following the indigenous communities judicial system, while we are following the colonial or neo-colonial judicial system, whereas Mr. Museveni said includes judges who are actors with wings. Yes, Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to the defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year, yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. Which is the same state saying we are the ones abusing the process. Therefore, our constitutional rights must be stripped. So, Judge, I beg this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us access, allow us time to access disclosures, and also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, Mr. Judge. Maybe what I forgot, we also talked about other parties which are inconvenienced by delays, saying we are looking at our own situation, not the situation of the other parties. The party, and this is a matter which you also touched on in your ruling on the human rights enforcement application. That those who apply for human rights enforcement seek to erase the rights of the victims. Our trial is of the nature that, because we are accused of treason, actions against the state. So the aggrieved party is the state. And it is the aggrieved party violating human rights in this case. Coming with gripping hands to seek justice. So I wish to reiterate that our applications cannot be an abuse of a process, cannot injure the other party, because it is the other party that is injuring us. So,
the registrar, criminal division, is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on the state brief. So, in order for the accused persons not suffer with the challenges of the legal team which keeps coming, the registrar should avail to the accused person that list of all lawyers in the state brief in the criminal division. And then this list will be given to the accused persons through Zira. For the accused persons to look at this pool and choose as a fallback, choose some lawyers of their choice for the purposes of this trial. And this registrar is directed to do it by tomorrow 14th and send this list to Zira through the criminal officers so that the accused persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. In alternative, for the purposes of this trial, if the accused persons don't choose the lawyers on state brief on their own and make their own choice, then I go ahead and make a direction that the registrar of criminal division by tomorrow, if the accused person have not chosen from the pool, then let the registrar go ahead and appoint the lawyers on state brief to help court and accused persons to proceed with this trial.
if what I heard and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly. Fair trial. Very clearly, very explicitly, non-derogably provides that the accused should be accorded enough facilities and time to prepare. If what you have provided that we start trial on Wednesday is the case,
Why can't you wait for folks to clarify?
this is, sir, the reason indeed we are very frustrated and we were even unwilling to come to court because this in many times appears as if we are irrelevant. We present whatever we present, court goes on with its script. So the impact will be that possibly you may have to try us in absentia so that it hastens the process. We give up our right to defend ourselves. You write a judgment and we deal with the judgment. Well, it will arise. It will arise because even the trial by state lawyers is a matter that we raise the concern about because we have been hearing it right from the way back that our lawyers will not be allowed to represent us, and indeed they have been tortured. The torture pictures published to the public and all the other lawyers, who after the pictures that were published of Counsel Erias Lukwago under torture.
Case number 335 of 2025, Uganda versus Cameroon retired Dr. Kizza Besigye, unable to turn RO stroke 12743, Captain Erias Lukwago.
May it please this honorable court, I'm Thomas Jatiko, Assistant Director of Public Prosecution. My Lord, I'm appearing together this afternoon with Richard Gumbuka, Chief State Attorney. My Lord, the three accused persons are present in court. However, my Lord, the counsel representing the accused person are all jointly and severally not present in court right now. My Lord, this matter was adjourned to today, the 13th of July. For hearing of the prosecution case as per the ruling that we received. And my Lord, the prosecution is ready to proceed.
Say you are ready to proceed.
Yes, the witness is in the court premises.
The witnesses are
They are around, not inside the court here, my Lord.
I came here by duress.
then first remove the handcuffs, then the places.
Yes.
Find a report on the issue of legal representation, why they are not here.
Yes.
Legal representation.
Yes. Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to the defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May last year. Yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. Which is the same state saying we are the ones abusing the process. Therefore, constitutional rights must be stripped. So, Mr. Judge, I beg this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us time to access disclosures, and also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, Mr. Judge.
This is the ruling of this honorable court. I have very carefully listened to the concerns from the chosen persons and the prosecution. The concerns and the reply from the prosecution, I will quote report, are not reproduced. And for the interest of time, I will give a summary of my ruling, and I will avail to you the detailed one later. But briefly, the Constitution told the court that they have witnesses around the court. The Constitution said that you are ready to proceed. However, the chosen persons, specifically A1, raised some concerns. Briefly, the concerns that affect the legal representation. To be specific, the concerns he raised is that one, that there is a pending application number 248 of 2026, which is still pending before this honorable court, and it is related to the issues of legal representation. According to the chosen persons, that is K1 and K2, they told the court that this application should be disposed of first. I will come back to that. They also raised the issue, the chosen persons, of the disclosure. The person said that the disclosure was made to their lawyers, who have since got the challenge, and for them, they have not received the disclosure, and also come back at it. The accused persons also informed the court that they want to be available with the record of proceedings in this case and the applications, which also come back to it. Another issue of concern was that the facilities in prison, which prison wrote this honorable court as of the 29th June, that they save be availed to the chosen and their team. Another concern is by S3, who raised the issue that he was not given a copy of the ruling in his bail application. Briefly, I will now proceed to make the following remarks and findings on those summaries of the concerns raised by the chosen persons. One, I am very well aware underlying of Article 28 of the 1995 Constitution. Briefly, Article 28 provides for the right to a fair hearing. I'll go ahead to Article 28.1. Article 28.1 provides that in determination of civil rights and obligations or any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. I have also considered Article 28(3)(d) of the 1995 Constitution. It provides that is 3D, that every person who is charged with a criminal offense shall be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. Indeed, from the time we started this case, the two persons were permitted the lawyer to the services of the lawyers of their own choice. Not until 30th June and specifically 3rd July, when the lawyers of their own choice that had been representing them were not present in court. I will now go to Article 28(3)(e). Article 28(3)(e) of the 1995 Constitution provides that, I quote, in the case of any offense which carries sentence of death or imprisonment for life, the accused is entitled to a legal representation at the expense of the state. In this instant case, and specifically the concerns raised by the chosen persons, I will address all their concerns one by one for the interest of justice. Concern 1, that Ms. application number 248 of 2026, which is allegedly to be pending before this honorable court, or specifically before me. Cases normally are allocated to the judges. Judges don't allocate cases to themselves. I want to make it clear that from my knowledge, Ms. application number 248 of 2026, which the accused persons are talking about, has never been allocated to me as a judge. It's not before me. But the registrar, I find out from the registrar who allocates cases. But the said application has never been allocated to me, and the same application I cannot use it or debate it to hold this trial, because it is not until that the same application is allocated to me that I would know the content. But at this stage, I don't know the content of that application, which has never been allocated to me, that I can form a mind to hold this file in session number 335 of 2025. I go to the issue of disclosure. The accused persons have told the court that the disclosure was made to their lawyers. True, from court record, the final and full disclosure was made on the 1st of June 2026. And I will take what the accused persons have told me, that they have never received such a disclosure since the disclosure was received by the lawyers who have since brought challenges. I now order and direct the prosecution that for the interest of justice, at the end of this sitting, I'm ordering you make avail of the disclosure to the accused persons before court here on their own, since the other one, according to them, was made their lawyers. So at the end of the sitting, prisons kindly hold on, allow the prosecution to avail all the evidence they intend to use in this case, avail it to the accused persons themselves. In case there is any challenge of the prosecution to do that, serve all the evidence they got rely on today, of which I believe I told court that they were already with witnesses. Yes, they had that evidence they intend to use, so avail it to the accused persons themselves. On the issue of proceedings, this case and other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribed. So the IT should help the registrar to have these proceedings in this main case and applications, so that the registrar can satisfy them and serve the accused persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with the Treason, they should get these proceedings and avail them to the accused persons. I will now proceed to the facilities in New Zealand. As the accused persons and specifically A1 put it, it is on record that at least by 29th June, the New Zealand people wrote this honorable court, and the letter is on record, that they had granted almost several facilities to the accused persons and their legal team, and directing Brazil to adhere on the same. One also go ahead and comment on the ruling for S3, that it was unfortunate that you have not received the copy of the ruling. Yet this court directed the registrar and the Brazil people to avail you with this ruling. I will now again direct the registrar to Brazil people, even Brazil people before you go, to make sure that find out where it is, whether with the registrar or in Brazil, so that this is able to get in the court. For the interest of justice, and specifically to address the issue of representation, the chosen persons have been represented by lawyers of their choice as per Article 28, 3D, from the time we started this case, at the time of the pre-taking. However, it is my considered view that the chosen persons were permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the chosen persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws in the case, such a challenge keeps on. Because my view is that there must be a solution for the trial to commence. And I am aware and alive of the right of the fair hearing. And my view, this case has suffered several delays. And indeed, that two of the persons have said they have been on remand for some time. So, this honorable court has decided to invoke Article 28(3)(e), which provides that two of the persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar criminal division is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on the state brief. So, in order for the accused persons not to suffer with the challenges of the legal team which keeps coming, the registrar should avail to the accused person that list of all lawyers on the state brief in the criminal division. And then this list will be given to the accused persons through zero. For the accused persons to look at this pool and choose as a fallback, choose some lawyers of their choice for the purposes of this trial. And this registrar is directed to do it by tomorrow 14th and send this list to zero through the prison officers so that the chosen persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. And this doesn't stop any other lawyer of the choice of the chosen persons to join the team of state lawyers, of lawyers of the state team. So the chosen still has the right to get lawyers of their choice, but in order for this trial have a direction, let us have a list of lawyers on the state brief from criminal division, selected, chosen by a chosen persons themselves. In alternative, for the purposes of this trial, if the accused persons don't choose the lawyers on the state brief on their own and make their own choice, then I go ahead and make the direction that the registrar criminal division by tomorrow, if the accused person have not chosen from the pool, then let the registrar go ahead and appoint the lawyers on state brief to help court and accused persons to proceed with this trial. I'm invoking Article 28(3)(e). In the same vein, for the interest of justice, if the registrar appoints the lawyers on state brief other than the accused persons choosing for themselves, then either way, if the accused persons select and choose and the registrar appoints, the prosecution is directed now to go ahead and prepare all the evidence they intend to use to give it these lawyers chosen by the accused persons or appointed by the registrar. So the prosecution gets in touch with the registrar to know if the accused persons have selected those team of lawyers, avail them with the evidence we intend to rely on. In conclusion, this case is adjourned Wednesday, 15th at 11, can meet here and know that the orders and directions of the court have been
Clarification.
Yes. Please let me put you with that.
Yes, please, on issues of clarification.
Yes, let me put you with that. Yes, please.
The first one on our application 248, which you have said is not before you.
That is number 248.
Yes, which is not before you. For us, we just make applications to the High Court. Now, this application very clearly directly relates to the matters before you. We have been presenting this matter before you since the 30th of June. In the appearance of the 30th, in the appearance of the 3rd. In the interest of justice, which you keep referring to, have you taken any interest to find out where this application is that relates to this matter very critically, and that fundamentally affects our rights? Once we file an application to the High Court, that's all that we can do, which we did. Secondly, I pointed out that we have filed a notice of appeal on the application, appeal on the ruling that you made in respect of application number 227. Again, an application that fundamentally impacts on the main case. So we have an interest in continuing to pursue that application 227 in the Court of Appeal. And if the process of trial continues as you have guided, then sure our appeal will be completely negated. Thirdly, the schedule you have given us now Did I get it correctly that, because I don't have anything to write on my, as I pointed out at the beginning, we were arrested from the prison and brought here forcefully. First time I'm being arrested in prison. So we didn't come prepared. But the question I'm asking on the schedule, did I hear correctly that the disclosures will be available to us in the course of this evening? That tomorrow we shall get a list of government lawyers from which to choose. Or if we have difficulty choosing, the registrar will tomorrow appoint lawyers for us. And that in the same tomorrow, the appointed lawyers will receive the disclosures from the prosecution. And that then trial will begin on Wednesday. If what I have and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly. Because you expect us to choose lawyers tomorrow, receive disclosures this evening. Disclosures, he said, we receive them this evening, they will be given, but lawyers will get from them tomorrow. So clearly we shall have no time at all to sit with the lawyers, whether of government or otherwise, to review the disclosures, which, as has been previously pointed out to you, are voluminous. And we should start trial on Wednesday. Clearly, if such a process is insisted on, I don't see.
I think ask clarifications, then I will give. So don't.
So I come back after you have clarified.
You first listen. Let me first know the clarifications.
So those are the clarifications, but the reason I'm asking for them is the concern that I am presenting. Or you want me to present the concern after you have confirmed otherwise?
I was saying let me get those clarifications. You said you have those clarifications you want, and so I gave you the things you raised.
Yes. I have raised the clarifications I need. I was now going to raise the reason these clarifications, if they are, especially the third one, which I have raised, if it is if I understood the guidelines on timings correctly, what its impact will be on us. If you want me to raise that later, I can.
Go ahead.
Yeah, so I was simply saying that fair trial, very clearly, very explicitly, non-derogably provides that the accused should be accorded enough facilities and time to prepare. So we are getting the disclosures this evening, hopefully. The facilities to use those disclosures, to access those disclosures are still a matter that is out there, whether we will get the facilities that we need or not. The lawyers are being appointed tomorrow and trial begins on Wednesday. So, that being and this is why I wanted to talk about Mr. Museveni's statement and impact, because he clearly directs a different legal justice system, where he says if an accused denies an offense, it is provocative and will be dealt with by those he has appointed to fill that gap. The criminal justice system that I present myself to arises indeed from the indigenous communities of this country, which made a constitution in 1995. That constitution is the result of all the indigenous communities in Uganda. So if there is another indigenous community that still has something different from this constitution and is using it to impact the process of legal justice now, this, you see, impacts on what I'm saying. I'm talking about the impact if what you have provided that we start trial on Wednesday is the case.
Why can't you wait for folks to clarify?
You see, sir, the reason indeed we are very frustrated and we were even unwilling to come to court, because this in many times appears as if we are irrelevant. We present whatever we present, court goes on with its script. So the impact will be that possibly you may have trials in absentia so that it hastens the process. We give up our right to defend ourselves. You write a judgment and we deal with the judgment. Well, it will arise. Because even the trial by state lawyers is a matter that we raise the concern about, because we have been hearing it right from the way back that our lawyers will not be allowed to represent us, and indeed they have been tortured. The torture pictures published to the public and all the other lawyers, who after the pictures that were published of Counsel Erias Lukwago, under torture. Now he's being taken to India for further surgery. Who will, if we don't resolve the environment surrounding our... Yes, but you say you don't know where it is.
Yes.
We have raised it on the 30th, we have raised it on the 3rd.
And requesting the court order, if the public will see that they want to be violent, and why can't you give them a chance to stop?
See, our frustration, sir, is that application which we made long before the bail things came in. We don't know where it is. It's a human rights center. Yes, and it impacts it. So we are now going to start trial because we have failed to get lawyers. You are providing state lawyers. We have not failed to get lawyers at all. We have the capacity to get the lawyers of our choice, but not in the environment the state has created, which we want court to deal with, so that then we can go ahead and appoint our lawyers and the case continues.
One of the concerns that arose in the ruling yes, Thomas Jatiko, Assistant DPP. I know the prosecution has carefully listened to the ruling, and this ruling orders or directs the prosecution to avail and disclose to the accused persons all the disclosure today before I believe they leave for the prison. Ballot is after 5 p.m. and the prosecution does not have all this evidence in court here to avail to the accused persons. And my lord, this evidence is voluminous, as the prosecution already served over 10 lawyers with this evidence that is constituted by witness statements.
So, are you saying therefore the accused should not?
My lord, we cannot disclose to the accused persons by the close of business.
So what are you suggesting?
My lord, we pray that the prosecution can be able to make this disclosure by Wednesday, because we need to have forensic evidence transferred by the forensic expert, who I am aware is presently in a training, and between now and the end of this court I cannot do so. Even tomorrow I cannot do so. I cannot be certain. My Lord, we would pray that this court be pleased at the most permit prosecution avail this evidence, at least by Wednesday, because for now and tomorrow it is not impossible. My Lord, this is because we already gave all the copies we had to the defense team, who are over 10 or 12 at the time, and we are only left with the original copies. My lord, in any case, the lawyers that have been representing the accused persons severally have these pieces of evidence. They can turn it over immediately to the accused person. We humbly pray. My lord, just in addition, from the further directives in this ruling, it also will mean that the prosecution may also have to serve the new counsel who will be selected. So, my lord, this period between now and the time the prison people leave, and even tomorrow, is not sufficient for the prosecution. And they reiterate our earlier prayer. God be blessed. Grant us more time.
Specifically on the issue of the schedules that this court has given. This honorable court has gave directions of each part, including the register and the constitution. I still say that the register unveil the accused person is list by tomorrow and send it to them for the accused person to choose the lawyers of their choice. For the use of disclosure, since the Constitution was saying that we don't have that evidence of which the chosen persons must get, prepare the same evidence that we intend to rely on, and then make a full disclosure here on Wednesday. It is on that Wednesday that this honorable court will know that one, the issue of legal representation is sorted, and the issue of disclosure is sorted. One conclude, commenting on the application, number 248, that as a judge, I don't go looking for cases. However, I will take interest now to meet. Because I was waiting, all cases which are located to me, I wait in quickness and tears. So that one by Wednesday, still you will know who is handling that case on the issue that is raised in this matter. Let us wait and see. Because I don't know the context, I have not known. But let us wait on Wednesday. As you have said, I'm going to find out mission straight. And on Wednesday, we shall harmonize who is handling that because of not knowing. So let us meet here on Wednesday at 11.
You haven't commented on the impact of our intended appeal in 227.
That one you said you appealed, and I have ordered that you get the proceedings.
Yes.
Yes.
So the trial will continue as we appeal.
Then the counsel, co-counsel, will help us. Now, you said you are getting a report from appeal.
Yes, there are some appeals with the office.
So let us tell them,
Yes.
the report. Now you want me to start now in this one, start again. I don't know what I can say. Entertaining that application. We will guide you through the process. All in that. Assuming Councillor Simon on that case. For me, what I'm going to do is let us get the report, the notes you have given it to me. Let us please get the report and you appeal. It is your right.
So by Wednesday, we shall have all the report.
I think so. What is it about?
Yes.